Elliott, and I'm the presenter for this training. This training is going to cover the parent rights in special education, which is also referred to as procedural safeguards. This training was created with funding from the United States Department of Education to the Louisiana Parent Training and Information Center, a program of Families Helping Families of Greater New Orleans, in collaboration with the Louisiana Department of Education, to be used by the statewide network of Families Helping Family Centers. To continue to receive funding to provide these 3 pieces of training, you need to complete an evaluation at the end. The evaluation results help us improve training and demonstrate the need for continued funding to provide these types of trainings free of charge. You'll be prompted at the end to complete the 2-minute evaluation. Everyone completing an evaluation will receive a copy of the PowerPoint and a certificate of attendance. If you lose audio, you can call in using the number you got in your invite through the email after you registered, or you can rejoin using that same link that you joined with too. I want to encourage you to submit questions in the chat box. You can also wait to the end because I'm going to do question and answer time then. Families Helping Families of Southwest Louisiana provides webinars, and eventually we're going to provide in-person training again on special education and disability related topics. You can check out our website at www.FHFSWLA.org regularly and register for any upcoming training that might be interesting to you. You can ask for specific training that's not offered on your evaluation. If you're interested in a topic, someone else probably is too. Part of being successful is having partnerships with others that promote the same ideology as we do. We believe all individuals with disabilities, regardless of the severity, have the right to live a meaningful life in their least restrictive environment and to the greatest extent possible. We realize this may look different for many people. However, we believe exclusion is unacceptable as a long-term goal. So our state partners include the Network of Families Helping Family Centers. That's 10 independently operated family resource centers across the state of Louisiana. The network of centers provides support around a variety of disability-related topics. If you have a disability-related question, contact your local Families Helping Family Centers. Then there's the Families to Families Health Information Center, which is a program of Bayou Land Families Helping Families. It assists families of children and youth ages 0 through 26 with special health care needs, mental or behavioral issues, disabilities, and medical concerns. Then finally is the Louisiana Council's Advocacy Network, also known as LACAN. It's a grassroots advocacy network advocating for individual and family supports and services and inclusion. You will be able to find links for all 3 of these on the slide when you get your PowerPoint. Part of our requirements under our funding sources is to demonstrate our training is useful to families of children with disabilities or suspected of having a disability. The pre-test is just a way to demonstrate knowledge learned during our training. We're going to take 2 minutes to ask you a few questions. You can answer those questions on the screen. Nobody, not even me, is going to know how you answer. It'll just be a total number. So the first question is true or false. One of your rights under the IDEA procedural safeguards is parental participation. The second question is true or false. Prior written notice is only required when the school is requesting an IEP meeting. Then you have to use that bar on the side to scroll down to see the rest of the questions. The third one is true or false. A school district cannot evaluate or reevaluate your child for special education services without signed informed consent from the parent. The fourth question, again, true or false. If you disagree with the results of your child's special education evaluation, you have the right to request an independent educational evaluation paid for by the school system. Then go down a little bit farther. True or false, a facilitated IEP meeting is part of the due process protocol. 6, true or false, school districts can refuse to participate in mediation hearings. Then 7, true or false, only an attorney can request a due process hearing. And I'm going to give everybody a little while to answer the survey. If you need more time, you can let me know in the chat box. Okay, we're going to go ahead and shut this down. And I'll start answering. Thank y'all, by the way, for doing the pre-test. Start learning some of the answers. Okay, so our learning goals are like this. We're going to start with frequently used acronyms and then go over a very brief background on the Individuals with Disabilities Education Act. We're going to move into your procedural safeguard rights and give you some definitions of procedural safeguards. Finally, at the end, it's going to be some really good Louisiana Department of Education website resources. If you participated in some of our previous training, this one's a little more interactive, and I hope everyone will participate in all of the activities. Throughout the presentation, I'll be using acronyms. I always want to give the full meaning and then state it's also known by and give the acronym. I might go back and forth though occasionally, so I want to provide you with this list up front before we get started. Some of the frequently used acronyms you'll hear in this training is LEA for Local Education Agency or School System. BESE is the Board of Elementary and Secondary Education, also known as the State School Board. IDEA is the Individuals with Disabilities Education Act. IEP is the Individualized Education Program. You're also going to hear FAPE, which is Free Appropriate Public Education. IEE is an Independent Educational Evaluation. FERPA is the Family Educational Rights and Privacy Act. And ERP is the Early Resolution Process. President Gerald Ford signed into law the Education for All Handicapped Children Act on November 29, 1975. The original law was only for children 3 years of age and up, but not for infants. It wasn't until 1986 that birth to the third birthday was added. It's now called Part C services, and then specifically in Louisiana is called Early Steps. The Individuals with Disabilities Education Act, also known as IDEA, provides specific rights to students and parents of students qualifying for or suspected of needing special education and related services. Those rights are referred to as procedural safeguards. These safeguards are designed to ensure parental participation in the special education process and to ensure the student's right to a free, appropriate public education, also known as FAPE. Procedural safeguards don't spell out what services you'll get. They describe the ground rules for how you'll work with your school. IDEA states schools are required to provide you, the parent of a child with a disability, with a notice containing the full explanation of procedural safeguards available under IDEA and the United States Department of Education. A copy of your rights has to be given to you at least once a year. But then you should also receive a copy upon initial referral or your request for an evaluation, the first time you file a complaint, and when a decision is made to take a disciplinary act against your child that constitutes a change of placement, and upon your request. In the chat box, please type one thing you think is a procedural safeguard under IDEA. Okay, maybe nobody knows what a procedural safeguard is. One person said prior written notice. So let's look a little bit. Procedural safeguard notice. Parental participation in the special education process. Access to your child's educational records. That's a procedural safeguard. Confidentiality of your child's information. You should expect that. Providing informed consent before certain things can happen. Receiving the prior written notice. Receiving information in a language or way that's understandable to you. Receiving an independent educational evaluation if you disagree with the school's evaluation is a procedural safeguard. Stay put rights. And then specific dispute resolution options. So let's jump in and learn some more about some of these. You have a right to the procedural safeguard notice. Your school must provide you with a written explanation of your rights under both IDEA and Louisiana laws. You must receive a copy of your procedural safeguards at your annual IEP meeting. If your IEP team meets more than once per year, they aren't really obligated to give you another copy, though they often do. The purpose of the procedural safeguards notice is simple. It's to inform parents completely about their rights available under IDEA and Louisiana laws. This includes all protection your child has as well. In Louisiana, this document looks like the picture on your screen and is called the Louisiana Educational Rights of Students with Disabilities. Special education processes and procedural safeguards. This document comes in English and 7 other languages. You can download it from the Department of Education website at louisianabelieves.com. In English, Arabic, Chinese mainland, Chinese Taiwan, French, Spanish, Urdu, and Vietnamese. Later, I'm going to show you how you can get to that document on the Louisiana Department of Education website. One of IDEA's foundational principles is the right of parents to participate in education decision-making regarding their child with a disability. The law is really specific about what school systems must do to ensure that parents have the opportunity to participate. Parents have the right to participate in meetings related to evaluation, identification, and educational placement of their child. Parents also have the right to participate in the meetings related to the provisions of the Free Appropriate Public Education, also known as FAPE. Parents have the right to be members of any group that decides whether the child is a child with a disability and meets the eligibility criteria for special education and related services. Parents have the right to be members of the team that develop, reviews, and revises the IEP for their child. Parents have the right to be members of any group that makes placement decisions for their child. Section 1400C5B of IDEA. So you could go to the law and look under those headings. It says after 30 years of research and experience has demonstrated that education of children with disabilities can be made more effective by strengthening the role and responsibility of parents and ensuring that families of such children have meaningful opportunities to participate in the education of their children at school and at home. Parents have the right to see and get an explanation of their child's educational needs. You can ask for corrections and additions. These rights are protected by IDEA and FERPA, the Family Education Rights and Privacy Act. The participating school district must permit you to inspect and review any educational records relating to your child that are collected, maintained, or used by your school district under IDEA. The participating agency must comply with your request to inspect and review any education records on your child without unnecessary delay and before any meeting regarding an individualized education program or an impartial due process hearing, including a resolution meeting or hearing regarding discipline, and in no case longer than 45 calendar days after you've made the request. Your right to inspect and review educational records includes one, your right to a response from the school district to your reasonable requests for explanations and interpretations of the records. 2, your right to request that school district provide copies of the records if you can't effectively inspect and review the records unless you receive those copies. And 3, your right to have your representative inspect and review the records. Each school district can charge a fee for copies of records which are made for you if the fee doesn't effectively prevent you from exercising your right to inspect and review those records. The school district can't charge a fee to search or retrieve the records, though. Each participating school district must keep a record of parties obtaining access to education records collected, maintained, or used under Part B of IDEA, except parents and authorized school employees. They have to include the name of the party, the date access was given, the purpose for which the party is authorized to use the records. If any education records include information on more than one child, the parents of those children have the right to inspect and review only information relating to their child or to be informed of the specific information. On request, each participating school district must provide you with a list of the types and locations of education records collected, maintained, and used by the agency. Parents have the right to expect a school to protect their child's information. Confidentiality of information includes personal information like your child's name, address, social security number, other personal details. You have a right to expect your child's personal identifying information is kept confidential. It can be the previously mentioned information, a list of personal characteristics, or other information that make it possible to identify your child with reasonable certainty. Your school district has to tell you when personally identifiable information is destroyed. They have to tell you when it's collected, maintained, or used, or when what is collected, maintained, or used is no longer needed to provide educational services. Then it must be destroyed at your request, but they can keep a permanent record of your child's name, address, phone number, grades, attendance records, classes attended, grade level completed, and the year completed, and they can keep those without time limitation. So here's another little poll. One question. True or false? Informed consent can be verbally or in writing. Let's see if I can launch the poll. All right, there's the poll. You can hit true or false. I'm not going to know who said what, so feel free. Click it on your screen. If anybody needs more time, you gotta just let me know in the chat box. I'm fixing to end this one. So let's find out. Informed consent is another one of your rights. Before the school district can evaluate your child or provide special education or related services for the first time, the school must inform you of what's involved. You have to give consent in writing before the school can move forward. Informed consent is one of your procedural safeguards. It means you've been fully informed in your native language or other mode of communication of all information about the action for which you're giving consent. You understand and agree in writing to that action, and the consent describes that action and lists the records of any that will be released and to whom. And you understand the consent is voluntary on your part, and you can withdraw your consent at any time. So, informed parental consent is required before the school conducts an initial evaluation, and before the school conducts a reevaluation, and before the school provides special education services, and before the school invites non-school agencies to participate in IEP meetings. That happens particularly in the transition years in high school. The school district must make reasonable efforts to obtain your informed consent before providing special education and related services to your child for the first time. If you don't respond to provide your consent for your child to receive special education and related services, or if you just don't want to give your consent or revoke your consent, your school district may not use other procedural safeguards like mediation, due process, resolution meeting, or due process hearing to obtain agreement or a ruling that special education and related services may be provided without your consent. Your school district is not in violation of FAPE and not required to have an IEP meeting if you won't give consent or you revoke your consent. That's also true if you don't respond to the school district when they request consent. The school has to give you prior written notice before it changes your child's special education program. That includes when the school wants to add or deny services. If a school wants to make changes to your child's IEP, you need to be informed and participate in the decision-making process. The prior written notice provision under IDEA says the school must give parents written notice anytime it adds, changes, or denies educational services to their child or wants to change the child's placement. The content of that written notice must, 1, describe the action your school district proposes or refuses to take. 2, explain why your school district is proposing or refusing to take the action. 3, describe each evaluation, procedure, assessment, record, or report your school district used in deciding to propose or refuse the action. 4, include a statement you have procedural protections under the procedural safeguards provision in Part B of IDEA. 5, tell you how you can obtain a description of the procedural safeguards if the action that your school district is proposing or refusing is not an initial referral for evaluation. 6, include resources for you to contact and for help in understanding Part B of IDEA. 7, describe any other options your child's IEP, Individualized Education Program, team considered and the reasons why those options were rejected. And 8, provide a description of other reasons why your school district proposed or refused the action. So examples of when the prior written notice include when the school wants to conduct an individual evaluation at the very beginning, when the school says no to your request for an evaluation or services or placement in another educational setting, or when the school wants to change how it identifies your child's disability, or when the school wants to change an educational placement, such as going from general education to the special education classroom, or when the school wants to reduce, add, or any way change your child's educational service. The prior written notice is often overlooked by parents and the school, but it ought to be something both parties want to do. It provides excellent written documentation of a request and/or denial. Even if the school system calls you to inform you of a change, that call doesn't satisfy this requirement of the law. If the school district offers parents the choice of receiving documents by email, you can get these things by email: prior written notice, the procedural safeguards notice, and notices related to a due process complaint. So let's try another poll. If the parent only communicates by sign language, is the school required to provide a sign language interpreter for school meetings and other events? You got three choices. A is yes, they are, as this is a reasonable accommodation for the parent. B, no, they're only required to provide sign language interpreters to students with deafness. Or C, I'm not sure what the school district's responsibility is to parents. We're going to give everybody a few more seconds to answer. Okay, let's go see what the answer is. You have the right to get all information from the school regarding the identification or delivery of special education services in an understandable language to you. Whenever the school provides you with written notice, it must use language that's understandable to the general public. The notice must be in your native language or other modes of communication you use, including Braille, unless it's clearly not feasible to do so. If your native language or other modes of communication is not a written language, your school must ensure the notice is translated for you orally or by other means in your native language or other modes of communication. You understand the content of the notice, and there's written evidence the requirements have been met. Native language, when regarding an individual with limited English proficiency, means the language normally used by that person, or in the case of the child, the language normally used by the child's parents, and in direct contact with the child, including the evaluation of the child. The language normally used by the child in the home or the learning environment. For a person with deafness or blindness, or a person with no written language, the mode of communication is what the person normally uses, like sign language, Braille, or verbal communication. You have the right to obtain an independent educational evaluation, or IEE, if you disagree with the evaluation of your child that was obtained by your school district. If you request an independent educational evaluation, the school district must provide you with information about where you can get the independent educational evaluation and about the school district's criteria that apply to the independent educational evaluation. The independent educational evaluation means an evaluation conducted by a qualified examiner who's not employed by the school district responsible for the education of your child. Public expense means the school district either pays for the full cost of the evaluation or ensures the evaluation is otherwise provided at no cost to you, consistent with the provisions of IDEA, which allow each state to use whatever state, local, federal, and private sources of support are available in the state to meet the requirements of IDEA. You have the right to an independent educational evaluation of your child at public expense if you disagree with an evaluation of your child obtained by your school district, subject to the following conditions. If you request an independent educational evaluation of your child at public expense, your school district must, without unnecessary delay, file a due process complaint to request a hearing to show its evaluation of your child is appropriate, or provide the independent educational evaluation at public expense unless the school district demonstrates in a hearing the evaluation of your child that you obtained did not meet the school district's criteria. If your school district requests a hearing and the final decision is your school district's evaluation of your child is appropriate, you still have the right to get an independent educational evaluation, but not at public expense. If you request an independent educational evaluation of your child, the school district may ask you why you object to the evaluation of your child obtained by your school district, but the school district may not require an explanation and may not unreasonably delay either providing the independent educational evaluation of your child at public expense or filing the due process complaint to request a due process hearing to defend the school district's evaluation of your child. You're entitled to only one independent educational evaluation of your child at public expense each time your school district conducts an evaluation of your child with which you disagree. If you obtain an independent educational evaluation at public expense, or you share with the school district an evaluation of your child you obtained at a private expense, your school district has to consider the results of the evaluation of your child. If it meets the school district's criteria for an independent educational evaluation, and any decision made with request to the provision of a free, appropriate public education or FAPE to your child, and you or your school district can present the evaluation as evidence at a due process hearing regarding your child. If the independent educational evaluation is at public expense, the criteria under which the evaluation is obtained, including location, the qualification of the examiners, must be the same as what the school district uses when it initiates an evaluation, to the extent those are consistent with your right to an independent educational evaluation. Stay put can be used when you disagree with the proposed change to your child's IEP services or placement. The stay put protection keeps your child's current IEP in place while you and the school district work on a solution. The stay put provision allows you to dispute a change without the change taking effect. And it includes all IEP services, including related services. When you use your stay put right, your child's services continue as is without any changes. Ideally, parents and schools are going to work together to come up with a solution. However, there are occasions when parents and schools can't find a resolution. So there's some important facts to know about stay put. First, the parents can only invoke their stay put rights before a change occurs. So the prior written notice we spoke about before must be sent to you, notifying you before the proposed change. Once you invoke stay put, you need to take some action. This is usually done through the dispute resolution processes we'll learn about next. If you go through one of those processes, the school will be required to keep your child in their current placement and receiving the same services until such time a decision is made through that dispute resolution process. There is one exception to stay put. If your child engages in a behavior that leads to a change to an alternative placement and you file an appeal, the student remains in that interim alternative education setting pending the decision of the hearing officer or until the expiration of the time period of the disciplinary change in placement, unless you and the school system agree otherwise. Another little activity. This one I want you to type in the chat box. Name one of the dispute resolution processes that are voluntary for both the parent and the school. So we're looking for a dispute resolution process that's voluntary. No answers. This one was a hard one, though. Let's see if we can figure out the answers. So, unfortunately, sometimes you disagree with the school district about your child's education and you can't come up with a resolution. Under IDEA, you have additional rights when you need a more formal process to resolve your dispute. You can use these processes to come up with a resolution around your child's disability identification, evaluation, eligibility, placement, services, or reimbursement of services you obtained privately. IEP facilitation is a non-adversarial dispute resolution method offered by the Louisiana Department of Education that's free of cost to both the parents and the school. Both parties must agree to the process, and if they do, the state will assign a neutral person called an IEP facilitator to help with the process. Mediation is another way to resolve differences that is also voluntary and requires an agreement by both the parents and the school. The next complaint and dispute resolution process is informal complaints. It's the policy of the Louisiana Department of Education to encourage and support prompt and effective resolution of any complaint in the least adversarial manner possible. The implementation of the early resolution process by each school district draws on the traditional model of parents and schools working cooperatively in the educational interests of their child to achieve shared goals of meeting the educational needs of students with disabilities. Then there's formal complaints. That's under procedures developed under the supervisory jurisdiction of the Louisiana Department of Education to address allegations the school district is violating a requirement of IDEA. A parent, adult student, person, an organization can file a signed written complaint by mail, fax, email, telecommunication for the deaf, with the Louisiana Department of Education. Then there's the due process hearing. That's the most formal of all the complaint and dispute resolution processes. It's more like a court proceeding in which evidence is presented to an independent hearing officer to resolve a dispute between you and the school district regarding your child. Only you, your attorney representing your child, or the school district can request a due process hearing regarding a student with a disability. So, using complaint and dispute resolution processes should always be your last resort after you've tried to resolve your issues more amicably. We encourage families to contact their local Families Helping Families Center with assistance in resolving school issues. To learn more about those dispute resolution options, you can join us for one of our upcoming training on dispute resolution options. That was just a quick overview. So, I want to do the post test, but I don't want y'all to disappear. We've got some great resources to share with you, and we'll take you on a tour of the Louisiana Department of Education website. But I want to do this post test. This is the same questions I asked in the beginning. We've gone over each of them during this training. Participating in our pre and post test provides us with measurable data on how effective the training is in increasing your level of knowledge on this subject. Like I said earlier, your individual information isn't collected or reported. Nobody knows, not even me. The only information collected or reported is the overall effectiveness of increasing your knowledge for participating in the training, and your participation is truly appreciated. So let's get started. 1, true or false? One of your rights under the IDEA procedural safeguards is parental participation. 2, true or false? Prior written notice is only required when the school is requesting an IEP meeting. Then remember, you use this bar on the side and go down to see the rest. 3, true or false? A school district cannot evaluate your child for special education services without signed informed consent from the parent. 4, true or false? If you disagree with the results of your child's special education evaluation, you have the right to request an independent educational evaluation paid for by the school system. Keep going down. 5, true or false? A facilitated IEP meeting is part of the due process protocol. 6, true or false? School districts can refuse to participate in mediation hearings. 7, true or false? Only an attorney can request a due process hearing. So I'm going to give this a little bit longer because I know all 7 questions takes a while to read through, even if I'm reading them. I think we can go ahead and end this poll too. I really appreciate y'all doing this. So let's look. I like my cat if it aced it. Let's look at those resources I was promising you. If you go to www.louisianabelieves.com and click where the blue arrow is pointing, the Louisiana Department of Education's website is filled with lots of resources, but many were developed just for parents. So you're also going to get an email with this information. See this, students with disabilities. Then it takes you to this page. The very first parental right I discussed was your right to procedural safeguards notice. I showed you what it looked like, the front cover in Louisiana. I'm going to show you where you can find it on the website. So if you go to this page by clicking the students with disabilities and you see this green bubble and families, and you click on guidance and information, it's going to bring you to a document named Resources for Parents of Students with Disabilities. Let's see. Let me go back. On page 2 of the document under Special Education Rights, you're going to see the Louisiana Education Rights of Children with Disabilities, and all 8 languages can be there. You'll also see on this page Bulletin 1508, which is the Pupil Appraisal Handbook, and it'll give you information on how students are evaluated for special education services. 1530 is the Louisiana IEP Handbook, and then Bulletin 1706 is the Louisiana Regulations to IDEA. There's lots of other resources here. Before we leave, I want to show you the Strong Start 2020 guidance that's specific to students with disabilities. We're going to go back to that page that we got after we clicked students with disabilities, and we're going to go down here to Strong Start 2020 section. That's where you're going to find COVID-19 resources provided by the Louisiana Department of Education. Lots of good stuff in there. If you need additional support on your parental rights or other education issue, you can call us at 1-800-894-6558 toll free. If you're in Southwest Louisiana, call us at 1-337-436-2570. People email us all the time at info@FHFSWLA.org. You can find me there too. You're welcome to email us. We have lots of great information on Facebook, Twitter, Instagram. You can like us, follow us, share our posts, retweet us. You can be added to our newsletter list and find other great resources at FHFSWLA.org. Let me check the chat box real quick. Wallace is my co-worker that's been working in the chat box and helping me do the polls. Wallace makes everything so much easier, and I want to make sure and tell everybody and thank him. So when we're finished and you end this, you're going to see the evaluation. But if you don't want to do it that way, again, Wallace put a link to the evaluation in the chat box. If something happens and you miss it both of those ways, when you get in the email, you're going to get a link to the evaluation. You're going to get the PowerPoint and the certificate of attendance as well. Thank you so much. If you do your evaluation, we take those seriously. They help us improve the quality of our training and, well, your experience. All of our funders require evaluation, and it helps demonstrate the need for free trainings like this. And we like being able to provide these trainings free of charge. Takes less than 2 minutes. If you're participating and you didn't register and you want to let me know in the chat box, Wallace and I can make sure you get counted and you get your own copy of the PowerPoint and your own certificate of attendance as well. We can hook you up. So I'm happy to take any questions at this time. I haven't really seen any in the chat box, but you know, I appreciate your coming. I'm gonna hang out for a while. So if you want to use the link in the chat box, do your evaluation and come back here. We appreciate your participating in the training. Don't forget to look at our website for all of our upcoming training and events. And like I said, I'm just going to hang out here a little bit for a few minutes. If you have questions, chat me up.